We'll start with Franklin High School. Whenever you're ready.
Yes, Your Honor. Your Honor, is Mr. Chief Justice or Madam Chief Justice?
She's the presiding justice.
Thank you. Madam Chief Justice, and may it please the court, my name is Sophia Yan, and I am here on behalf of the appellant, not so innocent, to demonstrate that Ms. Innocent did not relinquish her United States citizenship. My co-counsel, Adriana Romero, will be showing how Ms. Innocent is innocent of treason. My other co-counsel, Edward Gifford, will demonstrate how Ms. Innocent does not meet the requirements of an enemy combatant, and Catherine Chow will rebut. Today I will refer to the Nationality Act and Mr. Justice Douglas' opinion in Calkia v. United States to support Ms. Innocent's citizenship. Now, Ms. Innocent was born in the United States and therefore automatically acquired her U.S. citizenship, but she was shortly taken to Indonesia by her parents. Her father soon became the government minister, and as father of Ms. Innocent, he most likely paid for her living expenses from shelter, food, education, and all that. Now, her father's job required that Ms. Innocent signed the exclusive loyalty oath when she turned 18. And according to the Nationality Act, one may lose their citizenship by voluntarily and with the intent of relinquishing their citizenship by taking an oath or making affirmation or other formal declaration of allegiance to a foreign state after having attained the age of 18.
Counsel, I have a question for you. You stated at the beginning that because she was born in the United States, she automatically was granted U.S. citizenship. Is it an automatic function, or does that just make her eligible to become a U.S. citizen and she later has to go through certain procedures? Or was she, as soon as she was born, she was a U.S. citizen?
Your Honor, as soon as she was born, she was a U.S. citizen. And now, also Ms. Innocent has just turned 18, so it is reasonable to believe that she is still in high school and therefore financially dependent upon her father and emotionally dependent as well, as he is her father. What compelled Ms. Innocent to sign the oath for her father to keep his job. If her father had lost his job, then financial security would be hard in today's monetary-driven world. And therefore, she did not voluntarily sign it with the intent of relinquishing her citizenship. And for intent, we may look at the Kawakia case for examples of intent. And now Mr. Kawakia, he became an employee of the Japanese government. He worked in a prison camp. He showed hatred towards American prisoners and America. Now he tortured, taunted, and terrorized U.S. prisoners, yet he was still ruled to have had no intent of relinquishing his citizenship. Now, Ms. Innocent did a lot less. She never went outside and terrorized American tourists that were visiting Indonesia. And she was also apolitical. She never showed any hatred toward America. And also, she never signed a form renouncing her American citizenship. She only signed an oath asserting her Indonesian nationality, which can be analogous to Mr. Kawakia registering with the family census, asserting his Japanese nationality. Ms. Innocent also exercised her citizenship when she came to the United States later for college, which demonstrates that she may have wanted to keep her citizenship. Also, if she had wanted to relinquish her citizenship, she would not purposefully say that she felt no particular loyalty towards the United States or that she is apolitical. She would reasonably have gone even more protected to show that she did not relinquish her citizenship. And for these reasons, I urge the court to rule in favor of the appellant. And now my co-counsel, Adriana Romero, will address Ms. Innocent's sentencing.
Just a quick question, clarifying question. So you're saying essentially she was coerced into signing the loyalty signed in Indonesia, and that for that reason, it wasn't renouncing her citizenship in the United States?
Yes, Your Honor. She was compelled to sign it for her father, and therefore she did not voluntarily sign it with the intent of renewing her United States citizenship. Thank you.
Madam Chief Justice and may it please the court, my name is Rio Americano, and I'm here to show that my client, Ms. Natso Innocent, did not commit treason. The constitutional definition of treason provides that treason against the United States shall consist only in levying war against them or adhering to the enemy, giving them aid and comfort. The case laws in Calcutta and Help show that treason needs to have the element of intent to commit these treasonous acts. Though Ms. Innocent did buy these two parts that were later used for a treasonous act in a dirty bomb of jihadism, she was not knowingly or willing to aid or intentionally taking part in the action of committing the treasonous act. Your Honor, in Help, Help was knowingly aiding his son. He knew of his son's intentions, aiding the Nazi cause. In Calcutta, there was 8 overt acts that he was explicitly abusing American soldiers and going beyond the duty of, going beyond his call of duty. Ms. Natso Innocent was merely just helping or being sympathetic to her boyfriend.
Question for you about that though, because we know she bought the parts, and we know she gave them to her boyfriend to use them in a dirty bomb, or was planning to use them in a dirty bomb. And we know that at the time that she bought them, she also knew that they were not for the intended, or for why he had told her that he wanted the parts. Correct.
Correct.
So she may have known, or at least had a very good idea of what he was intending to use them for, knowing his radical political positions. Isn't that enough to take it to trial? Isn't that the question here? It's not. We're not judging her guilt or innocence.
Your Honor, this shouldn't even be brought to a jury. There's not enough evidence that shows she was knowledgeable or even possibly knowing or assuming that her anti-American or radical boyfriend would become a terrorist. Our Constitution supports free speech and encourages this kind of behavior, but it doesn't. There's no evidence that shows that she was knowledgeable of his intentions to hurt thousands of Americans. There's no evidence that these parts could be used in a other than a ham radio. Though the clerk said, this is not suspicious, but said, I could not imagine these parts being used in a ham radio, he did not infer that I cannot imagine these parts used for a ham radio, that must be used for a dirty bomb. There's no other evidence that shows that she was knowledgeable about what he was doing. The case before us is so much different from Help and from Kramer, which is also mentioned in Help, and Calcutta. For example, in Kramer, it seemed innocent on its face, yet when examined in light of its context and purpose, it was treasonable because he was knowingly talking to an enemy of the United States. And also in Help, he was knowingly aiding his son, and in Calcutta, he was knowingly performing these acts. Your Honor, they went beyond the call of what they were supposed to be doing. They were willing to adhere to the enemy. There was nothing that Ms. Innocent was doing to intentionally hurt American lives. Furthermore, it says in Help, in the dissent of Justice Murphy, an act may spring from the well of human kindness. Ms. Natso Innocent, being her boyfriend, being Jihad's boyfriend, was only acting out of sympathy. And also, it also says that an act may be successful in the effectuation of an act, but not be treasonable in light of its context and purpose. Your Honor, if we also look towards the case laws, it says that proof of intent involves proof that the accused committed the overt act with the knowledge and understanding of its treasonable character, as said by Justice Douglas in his opinion of the court. There was also no evidence that shows that any surrounding circumstances were even rise to reasonable suspicion or substantial evidence. Your Honor, a high crime of treason should not be taken lightly, or it should not be. We should not easily accuse people so easily on just little evidence. It should rest on something more substantial than reasonable doubt. And there's nothing. It does not even rise to reasonable or substantial.
Given the potential severity of the crime, though, shouldn't we be a little bit more lenient with respect to the amount of evidence that needs to be shown to go to trial? And if you're right, and it was all out of the goodness of her heart, and she was just doing the boyfriend a favor and completely unknowingly, then that will come out in a trial. But if you're wrong, and she did have some knowledge of what was happening, and she did have some intent to participate, shouldn't we also allow that, the potential for that information to come to light?
Your Honor, the facts before us, which we can only judge upon, show that there was no evidence. We can't assume or bend the facts to what we have before us. And the facts before us show that she was not knowledgeable and she was not intending or willingly aiding the enemy, which is not so innocent. And for these reasons, I urge the court to find in favor of the appellant. And now my co-counsel, Edward Rickford, will discuss the issue of enemy commitment.
Madam Chief Justice, and may it please the court, my name is Edward Rickford, and I'm here to show that Nassau Innocent is not an unlawful enemy combatant. The tragic events of September 11th made us bring back terrible memories of pain and anger for everyone. But we should not let these emotions cloud our judgment. Nassau Innocent is a human being, and the terrible events of this day should make us realize the importance of every human life. We should not devalue Miss Innocent's life just because she's thought to have affiliations with Al-Qaeda. The President's executive order states that any individual who is not a United States citizen is subject to the order if there is reason to believe that individual is or were a member of the organization known as Al-Qaeda. There is no reason to believe that Nassau Innocent is a member of Al-Qaeda. There is no physical evidence to prove that Ms. Innocent is a member of Al-Qaeda. There is no reason to treat her like she's a member of Al-Qaeda. The respondent will try to argue that she's a terrorist just because she did a favor for her boyfriend, but this is ridiculous. There's nothing to prove that. There's nothing to show that she knowingly bought the components for the bomb because she thought she was buying the components for a bomb. Her boyfriend took advantage of her innocence and her trusting nature to exploit her. He did this so that he could have a bomb, not so that she would be his sidekick. Just because she was not suspicious of her boyfriend does not mean she had malicious intent. We should not assume that because she did not think her boyfriend was building a bomb, that she's also indictable in his plans to build a bomb.
Counsel, I think what disturbs the court is that not one but two individuals, her friend and also the employee at Radio Shack, indicated to her that there's this information that should have informed her and made her think twice in light of the job that her boyfriend was sending her to do instead of doing it himself. Do you think that this young lady who is of college years, and I believe the reason why she, believe that she took advantage of her U.S. citizenship, or her former U.S. citizenship, since that's an open question, to gain access to college? She's an educated woman, and she did have this information and chose to disregard it. Can you speak to that?
Your Honor, they only indicated that the parts she's buying could not be used for a ham radio. The sales clerk said he could not imagine how the parts could be used for a ham radio. That does not mean they couldn't be used for a ham radio. And furthermore, it is more likely that she would trust her boyfriend than a sales clerk who is a complete stranger to her. The next part of the definition states that the individual must have knowingly harbored one or more individuals who is affiliated with the organization known as Al-Qaeda. Her boyfriend allegedly has ties to Al-Qaeda, but that does not mean we should try Nassau Innocent as an Al-Qaeda member. She never knowingly harbored Mr. Hadosan. She never knew anything of his connections to Al-Qaeda, and she never harbored him in the first place. The final part mandates that it be in the interest of the United States that such individual be subject to this order. Ms. Edison is no threat to the American people, and there's no reason to treat her like an enemy combatant. The military tribunal should be reserved for serious criminals, and we should not sully the good reputation of these criminal hearings by trying Ms. Edison. The United States government has always tried to be sensitive to the plight of suffering people. And if we are to honor this American creed, then we cannot try Ms. Edison in a military tribunal.
Counsel, do you have an opinion as to whether or not she's a U.S. citizen based on her signing the loyalty oath to Indonesia?
Your Honor, please clarify, please restate the question.
So, do you have an opinion as to whether or not Ms. Innocent is in fact an American citizen or a citizen of Indonesia based on the fact that she signed the loyalty oath?
Your Honor, I believe that dual citizenship is entirely possible under the realm of international law.
So, in spite of her signing that exclusive loyalty oath, it's your opinion that she still has dual citizen status between both countries?
Your Honor, in international law, you can be loyal to both countries.
All right, so your position is that she's not an unlawful enemy combatant based on the fact that she still retains U.S. citizenship?
Your Honor, I believe that she is not an unlawful enemy combatant because she's not committed any crime, and I don't believe she's done enough to relinquish her U.S. citizenship. Nassau Innocent is still a human being, and we should not try her in a military tribunal where she would not have all the same rights. If we were to try her in a military tribunal, she would not have the right to a speedy trial. She would not have the right to a defense counsel of her choice. She would not have the right to a jury of her peers. These are all rights that every person should have, and we should not take them away from Nassau Innocent.
But the President of the United States said that not every person should have those rights. That there are certain people that are not entitled to those rights, and that she may be one of those. Well, he didn't say that, but the Justice Department found that she may be one of those people. And there is some evidence indicating that she may have satisfied the intent and knowledge to fit into that category.
Your Honor, I think you're referring to the executive order, and in the executive order, the President says that he must define somebody in writing as an enemy combatant. And he's not defined Nassau Innocent as an enemy combatant in writing at this time or any other time. September 11th made us realize that we had a new enemy that we needed to engage. We are in a time of war, and just because we are in a time of war does not mean we can forget what it means to be American. We cannot disregard the values and morals of America, otherwise we will become no better than an enemy. It is true that in times of war we are supposed to show a special deference to the executive branch of government, but the Hamdi case shows us that we are not supposed to show complete deference. The three branches of government are very important, and they can work in concert in times of war. It is inappropriate to try Nassau Innocent in a military tribunal with so little evidence. For this reason, and others, I urge the court to rule in favor of Ms. Innocent.
Thank you.
Madam Chief Justice, and may it please the court, my name is Catherine Chow, and I'm here on behalf of the appellant to rebut the respondent's arguments. Regarding the issue of whether or not she relinquished her United States citizenship, the respondent argued that taking an oath after the attained age of 18 to another foreign state with the intent of relinquishing her United States citizenship would have made her eligible to relinquish it. However, this oath was not done willfully or voluntarily by Nassau, and she was compelled by the government of Indonesia to sign the oath. And as stated in the Koseki, in the Kawakita case, that if this act of signing was done under the compulsion of the job or the law or some other influence, signing would not rise
rise to the gravity of relinquishment. And as we see, NASA was compelled and required by the government to sign it, so therefore, this action should not rise to the gravity of relinquishing her citizenship. And it was also said in Kawakita that Kawakita should only be held accountable only for performing acts of loyalty toward the country, which he was not required by Japan to perform. And in this case, NASA was required by Indonesia to sign the oath. Additionally, the opposing counsel stated that it would be easy for her father to find another job. However, we cannot place this burden upon 18-year-olds. 18-year-old, she's probably still in high school, or maybe she just graduated like a mere months ago. It is not her responsibility to decide whether or not her father should keep her job. So therefore, her financial well-being relies upon her father's job, and it would be foolish to simply give it away. The opposing counsel also stated that NASA felt no particular loyalty to the United States. However, in the Kawakita case, we see that he openly belittled and physically abused American prisoners, which, if anything, shows disloyalty to the United States. However, he was still a world citizen. NASA was simply apolitical, and it is outrageous that we should be holding her to the same gravity of Kawakita's offenses. Regarding the issue of treason, the opposing counsel stated that there must be 2 witnesses to the act, and as he conceded later, that these witnesses cannot prove intent. The opposing counsel stated that her boyfriend's radical views and the clerk should have made her suspicious. However, all of these circumstances provide no solid, substantial evidence that points to her boyfriend's, to her knowing her boyfriend's knowledge, her boyfriend's plans. It's stated in Justice Murphy's dissenting opinion in the Haupt case that an overt act of treason should rest upon something more than substantial and reasonable doubt. Treason has such serious connotations that its substance cannot be left to conjecture. We are accusing of a 20-year-old now, a 20-year-old college girl, simply doing a favor for her boyfriend of treason. That is ridiculous. The opposing counsel stated that Naso could assume that her boyfriend was planning something violent. Naso was simply helping her boyfriend, and as stated in Douglas's opinion in the Haupt case, that sometimes these acts are simply an act of assistance which springs from the well of human kindness. Her boyfriend was afraid of persecution, of prejudice by the American citizens following 9/11. This is a very reasonable concern of his, and she was simply assisting him and helping him get through life easier, as a girlfriend should. Regarding the issue of whether or not she's an enemy combatant, the opposing counsel stated that Naso was knowledgeable of Mr. Hanson's radical views. However, simply because he was he had anti-American radical views does not simply mean that he's a terrorist. In fact, the United States Constitution encourages diversity and it allows free speech. The main foundation of our government is based on free speech, and Mr. Hassan should feel safe and should feel he should be allowed to speak openly of his views. The opposing counsel also stated that the court must give great deference to the government. However, that does not mean the Supreme Court can simply roll over and give complete deference. We must still rule fairly, and in this case, also should not be ruled as a no fair combatant. Thank you.
All right. You started the whole thing out, and I want to tell you, I wrote your response to the questions that counsel is lobbying at you. You were just right on. You weren't shaken by it. You maintained your composure. You responded appropriately and relevantly to the questions that were asked, and then you got right back on track. And so I was very impressed with that. Again, because you started also the day. And so I felt that that was just beautiful, your delivery and coming back from the question to your argument. Anything you want to add? Okay. So then, Ms. Romero, good morning again. I put excellent command of facts and use of cases. And also, I I was impressed with your command of the procedure. You were asked a procedural question, and I was surprised to hear you respond to that. I didn't know that you would have any information on that level. And so also I liked how you actually had a line specifically where acne spring from the well of human kindness. So I liked your use of the quote. It told me that you had read the cases and you were impressed with certain phrases in the cases that you felt were salient in making your argument. And so I really liked how you clearly were prepared and knew your cases well and were able to work at those. So good job. And I know you guys have other studies, so this is impressive to me. High school's gotten harder. Mr. Redford, so you project so well. That's just wonderful. You don't take anything away from that. That's lovely. You stood up. It shows confidence in not only your what you have inside of your head, your knowledge bank, but that you're comfortable in front of other people, and that what you have to say needs to be heard, and you feel confident in letting people know what you have to say. So that is a gift that not everybody has. I am an ALJ, and so I preside over hearings, and you'd be surprised that there are counsel that you have to ask them to speak up so the court reporter can hear them. So that's nothing that you have to worry about. And it also does spring from your ability, your knowledge of the cases and of the fact pattern of the case. I also thought you had an excellent response to the questions. When the questions were lobbied at you, you were able to answer the question to get one back on track. And I think in appellate argument, that's probably the hardest thing. So not only you having to get off your outline to answer that question, but it can kind of discombobulate you. And you can also start thinking, what does she mean by that? What does he mean by that? And you can start thinking about all these other things, right? And you have to get back to where you were. And you did that quite well. So do keep that up. And then Ms. Chow. My goodness. So you have a natural gift too. On all levels, your command of the facts, your delivery, your ability to get back on point, on all levels, and your passion. It was clear that you knew these cases and facts inside and out. I like how you talk about, look, this is just a 20-year-old college student who's being accused of treason. So you were able to take the facts and personalize them and present them in a way that gave us a demonstration of who you were talking about. You brought the people off the page so that you could make these arguments. And you said radical views doesn't mean he's a terrorist. Again, you took the facts from these pages and you brought life to them. You breathed life into them, which is something you usually don't get outside of a trial forum. And you did it in an appellate forum, right? That's how I used to convince clients not to go to trial. I'm like, look, this stuff that's on paper is going to be a living color, right? Because there are going to be witnesses talking about it. You actually, in an appellate forum, did that for us. And so it was excellent on all levels. Thank you.
I'll try to be brief because she's the judge. You should give her, in real life, so you should give her more credit than you would. But I was also just blown away. You guys are fantastic. I did a lot of moot court in law school, and I argue in court now, and you guys did a lot better than some of you trained of us. Just really, really fantastic. And then I'll give you guys each a few brief comments. Sophia, I thought you didn't get to sit this week. You had a really good introduction, and the first 3 sentences out of your mouth, I knew exactly what everybody at the table was doing on your side, and who was arguing what, and where you were going. And it just sends a clear signal that you guys are organized and prepared, and it's just a great way to start off your argument. You had some really good analogies to case law. It wasn't just citing on case law, but you were taking law and applying it to the current situation, which I thought was great. And you handled the questions really well. Adriana, you also had a great response to questions, and I threw a couple of fairly tough ones at you, and you didn't even hesitate. In fact, I was really impressed with the responses, and also just a very well-organized presentation. Edward, I totally echo her comments. Fantastic orator. And you have good arguments. The one thing I would caution you on is be careful that you're not overly enthusiastic. There were a few times where you used the one word that stood out in my mind was you said that's ridiculous about their position, and it may or may not be true. And there may be a way to incorporate that kind of argument, but you have to be careful with it because it's not a legal argument. It's not you have to be really careful to back that kind of statement up. So if you're just saying that's ridiculous or, rhetoric that is not necessarily informative can sort of undermine your argument sometimes. So that was my only criticism. Other than that, fantastic presentation. And Catherine, I was also just really impressed with your rebuttal, and a lot of different levels. One thing that I found really difficult, with rebuttal arguments is timing, because you're sitting there throughout their entire argument, and everything that comes up, I'm sure in your mind you have a response. You're like, I gotta say this, and I gotta say that, and I gotta say that. But it's really difficult once your rebuttal comes up to be able to prioritize and hit every issue and the most important things in every issue. You can't hit everything in rebuttal. And you went through methodically all three issues and hit the key points on all three issues, which is incredibly difficult to do. So I'm really impressed with that. And you also made some direct responses to things that they had said, which was